Perfect, thank you. And thanks for the introduction. So Ray and I are going to talk you through an overview of intellectual property, and particularly with examples as to how it applies to software as a service, which is a very, of course, how would I say, a very important realm today in intellectual property. And you can see some of the examples we go through, and you can see how the importance of that plays out in this field. So about Bearskin and Parr. So Bearskin and Parr is an intellectual property boutique. And by that, what I mean is this is all we do is intellectual property. So if you have questions about patents, trademarks, designs, trade secrets, copyright, the enforcement and protection of those, we're the go-to firm for that. We have offices in Toronto, Mississauga, Montreal, and Waterloo. And the Montreal office is particularly important these days with the introduction of the new French language laws, especially on trademarks and marketing and introducing products and services into that particular province. We also have over 70 patent agents and lawyers on our staff. Basically, most of our professionals have technical degrees. I have a physics background. Ray is an engineer, and he can talk a bit about his background in a bit. And we have all these technical expertise, so we can really talk your language when we talk about inventions and what it is that you do. And in fact, having a variety of these technical backgrounds, whether it's life sciences, chemistry, again, mine is physics or engineering, software, electrical, etc., it really allows us to put together the right team to master technologies, because we do find nowadays that by and large, a lot of technologies are a blend of many things now. When I started in this business, a mechanical thing was something that was mechanical. A high-tech thing was something that was probably more high-tech, if you will. But nowadays, we have a lot of blending of technologies, particularly, for example, in medical devices. You can see the life sciences coming together with software and AI, for example. So it's a really interesting time to be in. And based on the depth of expertise of the professionals we have in our firm, we can put together the right team to match what it is that you need. So what is intellectual property? We're going to kind of go through that at a high level, but basically anything that that you've come up with, and it's really what separates your company from your competitors. And that can be, like Ray and I, we really focus more on inventions, patents, and things like this. But it can be other things as well. It can be your branding, your name. It could be the logos that you have. It can be the designs that the consumers associate with your products or services. But all those things are really intellectual property. They kind of go in buckets of patents, trademarks, designs, and copyright, which we'll talk about. But basically, this is all intellectual property. And there's two kinds of intellectual property, and kind of two broad buckets. There's the kind that the consumers see and appreciate, and that goes really more to your designs and to your branding and your logos. And then there's a kind that really help you distinguish functionally your products and services from your competitors. The consumers don't always appreciate what those are, although you might market those advantages. And that really gets into the patents and the trade secrets and things like that. So when you see patent pending, you might think, oh, that's really a cool thing. You may not know why it's a cool thing from a patent pending perspective, but it sounds good from a marketing perspective. But what you do know is, of course, the names and branding of that company, and you trust that. So with that, we'll move on to the next slide. Right?
Thanks, Stephen. Just a little bit of my background. My background is in computer science. I'm in the engineering and technology group at Bearskin and Parr, and I work mostly with patenting of anything that's computer implemented or has a software component. So this could be the actual computer itself. It could be a medical device that uses computer technology, or it could be an app that, for example, is used by your smartphone and has some kind of software that helps the software do its job, such as it might use artificial intelligence or machine vision in conjunction with your smartphone's camera. So that kind of thing is what I work on the most. So what does intellectual property do? So intellectual property rights are what are called negative rights. So basically they give you the right to stop others from using your IP. So for example, if you get a patent on something it will allow you to prevent your competitors from doing what you've patented, but it doesn't necessarily give you the right to do what is described in your patent. For example, you might have an improvement patent on some particular process of doing something, but for you to do that process, you might have to do or practice another process or component of a process that's been patented by somebody else. So you have to make sure that you're not infringing somebody else's patents. There are some, let's say, for example, the iPhone. I can't remember if this was an example that was used in the past to extol the virtues of patenting, or if there was to complain about it. But the order of magnitude of the number of patents and IP rights in an iPhone is in the range of 1,000. So I don't know if that's still the case or not, but that can give you some kind of an idea as to how many patent rights can be held in a particular device. So what is your intellectual property? This is something that your company should be looking at, or your startup, or you as an individual should be looking at when you're trying to decide whether you want to pursue patent protection or any kind of IP protection. And that is, what does your company do? What is it that makes your company or the products that you manufacture unique? And how do you want to protect it? So why is important? Well, usually it's the monetary value. And some of these things can be somewhat related, even if not directly, but indirectly to the value of your company. So such things as your reputation and the fact that you can transfer your IP rights. So some major examples in the last 10 years or so that are good examples that are probably still valid and relevant are, for example, the trademark for Google, worth billions, $44 billion, now estimated to probably be much more. You have IP valuation companies that do these kinds of things, but they don't necessarily publicly disclose what the certain different rights are for different companies and their IP that they own. So sometimes we don't have the most up-to-date numbers, but I think $44 billion kind of gives you a good sense as to how valuable certain rights can be, like trademark rights. The Amazon one-click patent was estimated at being $2.4 billion. So your ability to click through a purchase with just one click. The Apple versus Samsung lawsuit resulted in damages of $1 billion. So they can be quite valuable. So we're going to move on to trademarks and dive into that. So I'll pass it over to Stephen.
Thanks, Ray. So trademarks is one of those interesting things. It's a fairly, fairly inexpensive when it comes to intellectual property, but it can become one of your most valuable assets over time. And I use the word over time there because on the other slide that Ray had, he had things like Google and Apple and Amazon. And of course, these are very, very famous trademarks with very, very high value. But that's taken a long time for them to build that up. And this is what trademarks do. Over time, as your company becomes more successful and your products and services become more successful, the value of your trademark also increases. So it's one of those wonderful intellectual property assets that increases as your company increases. And so really, what do trademarks do? They really, through words, designs, all these things, is really an identifier that the consumers use to identify the products and services of your companies from others. And it's really to go against confusion. So really in trademarks, if someone's confused that, when they see a mark and they think that's someone else's things, then that is, of course, is confusion. And that's where you have a good case of trademark infringement. But for example, if you can clearly say, this is my trademark, and consumers know your trademark and they know the quality of the products and services you offer and associated with that trademark, that's where the branding and the value comes in. And more to that, it goes to the goodwill as well. And you can think about these things, think about Legos, for example, Lego bricks. When people hear the word Lego bricks, you associate that with a certain high quality building block toy. We know there's many other Lego brick-like products out there because the patents and the designs and the copyrights on Lego bricks have long since expired. This has been around for many, many, many years. But the trademark still endures and only gets more valuable year after year. And so when you go into a store, for example, and you see Legos, you immediately associate that product with the quality of those products, and you will say, I'm going to buy this because I may have good memories as a kid, and you know it's going to last forever and ever and ever. So you flip the slides. So here you can see some of the, again, more valuable trademarks in the software space. So particularly you can see Apple, and you can see Google, and you can see Microsoft, Amazon, Facebook, Samsung. All these are incredibly valuable brands, and no surprise, a lot of these are in the computer and software and service space. And it's no surprise because this is one of the fastest growing areas in the world right now. And in fact, we'll talk about patents a little bit later, but software patents are the fastest growing stream of patents being filed as well. So anyways, as long as you can maintain your trademark distinctive, you know, your value in that will go up. Now, trademarks, unlike technology, which we're going to talk about a little bit later, you can file a trademark even after you start using a mark. So for example, if you started to use a mark and you haven't yet gone through the registration process, you are accumulating rights under common law. And what that means is you do have trademark rights, limited, but you do have some rights under common law if you've been using a mark before you register it. Once you register the trademark, it becomes a federal grant and extends across the country. So what's the difference between a registered and a common law use of a trademark? Well, let's say, for example, Ray is using an apple. Well, we also use apples, bad example. But let's say he's using bearskin in the Toronto area, but he hasn't registered that trademark and he's using it for patent services. And so as long as his use of bearskin in the Toronto area is known, he can claim trademark rights in that area. That's common law. But if I independently use bearskin in Vancouver and I didn't steal it from Ray, you know, I would be able to do that because I independently came up with it and he does not have a federal right. So common law rights does give some limited protection, but it's really in the territory that your mark is known. Okay, and so it wouldn't stop you from if someone has a similar mark in a different territory, it wouldn't prevent you from, it wouldn't help you in preventing them from using that mark. As soon as you get a registered trademark, it again extends federally, and you would be able to stop someone in Vancouver who afterwards used your same mark in that market. You'd be able to say you can stop that, even though you haven't yet extended your use to Vancouver. So that's the benefit of the registration. It's a very small expense. It gives you a federal protection, and it also gives you further protection under the Trademarks Act for infringement, should you want to go after somebody, which is a much better test to be under for trying to stop someone from using your mark. You do have to do the trademark process in country by country, but wherever your main markets are that you're practicing your services or selling your goods or wares, you want to try and register your marks in those countries. And again, it is limited in term, but you can renew it basically forever. And Apple is a great example. It's been renewed many times. And you may look at this and wonder, well, how can you have different kind of trademarks here using the word Apple? And of course, you can do that so long as the goods and services are very, very different. And Apple as a computer company versus Apple Corp, which is the Beatles logo, and Apple Auto Glass were able to coexist. This kind of got blurred a few years back when Apple went from being a strictly computer company into music. And that gave rise to some litigation between Apple as a computer company and the Beatles company, Apple Corp, over that, because originally there was an agreement that Apple, the computer company, would never go into music. Of course, things never stay still. That's, of course, been resolved. And Beatles tunes can now be viewed on Apple Music. But it just shows you, if you're wondering why you can have different goods and services with similar marks, that can happen so long as those goods and services are, how to say it, clearly separated. So Schneider's the meat company, and Schneider, the trucking company, can coexist, because you wouldn't confuse Schneider Trucking with Schneider's deli meats you find in a grocery store. And Apple Corp had an agreement in place to separate their products and services until, of course, that broke down and Apple went into music. So there you go. Moving on to designs. Ray.
Thanks, Stephen. So industrial designs, which are also called design patents in the US, protect the visual feature of a shape or configuration, pattern, or ornamentation in a finished article. Now, this is something that has historically been used by companies that, for example, want to make their physical products distinctive. For example, they have a pot or a chair or a table that has a particular design that they want to give that's aesthetic. However, fairly recently, companies that have apps and software that have a graphical user interface to them have used industrial designs to be able to protect such things as the Uber icon, the teardrop shaped marker icon for that you see in Google Maps, for example, and the GUI for the iPhone, for example. So industrial designs can't be used for the functional aspect of the design. So for example, if it's a part of a mechanical device, it can't actually have anything to do with the gears or the levers or anything that actually has a functional aspect. It's purely the ornamental or aesthetic. But when it comes to graphical user interfaces, that's something where you can't actually look at it and say, you know, this is functional. So what some intellectual property specialists would say as at a high level is it part of the look and feel of the software? Is it something where you look at it and you say, okay, that's, you know, this is, for example, Dyson's update or animated GUI that you can look at and say, oh, that's how Dyson does it. But it can't be functional. So here's a few more examples. You have the receipt from Uber on the left. You have the different emojis from Apple in the middle, and you have the type font, one particular type font from for Samsung that they use in their on their phones, for example. Now, as I said before, US calls them design patents, where most of the rest of the world calls them industrial designs. So they have what's called the article of manufacture requirement. So it has to be tied to a particular thing, such as a chair, or in the case of GUIs, for example, a smartphone. But it's people have asked, well, what about projections or holographic imagery or VR or AR? So as with anything that is being developed, you have the offices, for example, the United States Patent and Trademark Office reviewing it. So we don't have a clear answer from them yet on that particular aspect of design patents. So now we're going to move on to patents themselves, which are also called utility patents.
All right.
Stephen.
So what are patents? So patents are what Ray and I do most of our day-to-day job. Patents really get into the functionality of what it is that you come up with, whether it's a product or a process, and often software patents fall within that process realm. Basically, it's, you know, it has to meet a few requirements to be considered useful for a patent. One, it has to be useful, it has to have utility, and that's usually not too hard a threshold to meet. In other words, you wouldn't really be having discussions about the patent process, or even you know, your how this fits within your company if it wasn't useful. But the other two requirements are more on the patent side, is really new. And when we say new in the patent space, what we mean is, can you find what it is you've come up with in one single disclosure, whether that disclosure is in a printed publication, an earlier patent, or earlier uses before your patent filing date. And if you can find that one disclosure before your patent application filing date, then your invention is no longer new and you will not be able to get a patent. And then the third thing is obviousness. And obviousness is very subjective. And obviousness is really where a lot of the money on patents is spent. And when you think about it, what obviousness means is we've told you the solution to the problem in the patent application. And now, looking at what's come before the filing date, can I find references, publications, disclosures, for example, or uses that if I put them together will come up with your solution? And you can imagine that's pretty subjective. That's known as obviousness. And what we do find in the application process is when we have to argue with the patent office, that's known as patent prosecution. How strongly we argue on that obviousness question really goes a lot to the success of the product and services in the marketplace. And really what we want to do is make sure we're in a good position to make those arguments. And so when we do basically file the patent application, you want to have a good search in place. So basically you will be having information there so you can kind of anticipate the arguments the examiner is going to make and face them head on and say, you know what, we knew you were going to say this out obviousness, but it's not obvious for these reasons. That's the patent prosecution process. Now, when we say patent prosecution, those arguments with the examiner, what we're really doing is we're entering into a contract, if you will, between you, your company, and the government. And that contract is a two-way process. Basically, the government will grant you a patent so long as you disclose your solution to the public. Okay, that's the government's interest in the patent process. And our job is to make sure that contract protects you for what you think you're entitled to. And the government's job is to make sure the public is protected by making sure that you're not taking more than you're entitled to. And that's that back and forth bargaining process. And like any other contract, I just want to put it out there that when you file your patent application, you actually want the government to reject your application, because like any negotiation or contract, if someone accepts your first position, what are you going to be thinking of? You're going to be thinking, oh, I could have asked for more. So in the patent process, it's not unusual. In fact, it's kind of expected that the government will reject your first offer because it's a bargaining process. And then, of course, we go back and forth and negotiate the contract on your behalf with the government to arrive at the appropriate scope of claims that you're happy with and the government is happy with, or maybe we can say that neither party's happy with. And that's probably a good compromise as well. But basically, people can move forward from that position. So it's a bargaining process. The patent process is a bargaining process. And like anything else, the more successful you are in the marketplace, the more aggressive you might be in that bargaining process as well. So next slide. So when you think about patents and you think about why you're entering this bargaining process for your innovation, your solution, because you're going to disclose what that teaching solution is, what are you getting in return? You're getting in the return the exclusive right to prevent others from, and these three words at the top are the words you want to think about in the patenting process. They allow you to give you exclusive right to prevent others from making, using, or selling what it is that you've come up with. So in the software space, for example, you will be preventing others from making, using, or selling that particular software process. Independent development is no defense, and that's really useful when it comes time to think about the software market. Same with reverse engineering is no defense as well. So if you have something that people can look at and say, you know what, if I have this product, I could take it apart and I could make my own. That's reverse engineering. The only way you can protect against that is through the patent process. Same thing with software process and things like that. If someone can look at that and say, you know what, I see what's going on here, and I can probably make an alternative solution. Really patents is the only way you can really protect against that, because once someone comes up with a reverse engineered product, if you don't have a patent, there's very little you can do about that. Terms of patents is limited. It's about 20 years. But I will say, and I'll put it out there, in most technologies, except for perhaps pharmaceuticals or some mechanical spaces, 20 years is more than enough time for, technology just keeps moving forward. So 20 years is more than enough time, I think, to have your patent protection for. So here's an example of a software patent. It's a system and method for secure transaction management. And it's owned by, who's that owned by?
Intertrust.
It's very small on my screen here.
Yeah.
Trust Technologies. And it gives you an idea of what, if you look this patent up, you can find it. It's available on the database. It's free. Anybody can look at it. It's a expired patent by now because it's 1999, so it's more than 20 years old. So it gives you an idea of what you can see in the patent space. And you can see from the few drawings you do see there that really it's flow processes and diagrams that you're protecting, not the code per se, not the language per se, but really the processes. And when we do a software patent, we're really thinking about it from what's going on at the machine level, not necessarily the consumer level, but the machine level. The consumer level is more outwardly facing in marketing, but the machine level is more what's going on with the processes. And we want to know what's unique about your processes and how to protect that in the patent space. So reverse engineering and things like that will not be as much of concern. So this is a good example of a patent application. You can take a look at it. You can look it up on the Google Patents or USPTO, and you can read it at your own disclosure, at your own leisure. But basically, you'll see in there that there is a disclosure, a teaching of what it is that they have tried to solve. And at the end of that, you will see a listing of something called the claims. And the claims is what Intertrust Technologies have delineated as what they view as their exclusive right that only they can make, use, and sell under that language of those claims. So when we do the patent prosecution process, that bargain with the government, what we're really doing is negotiating the scope of those claims. That's the contract portion, if you will, with the government. So here is a quiz.
So I'll just put it out there. I don't expect you to submit your answers, but just to think, true or false, or maybe, is software patentable? And the answer is maybe. The classic lawyer type answer. So generally speaking, if you want to patent your software, then you're not going to get very far if all you do is try to get a patent on the algorithm itself or the code. Some jurisdictions actually have a blanket exception, meaning that you can't get a patent on an algorithm per se or software per se. But you can get a patent on a practical application of a software. The classic case that the Canadian Intellectual Property Office likes to use as an example is software for oil well drilling. And if you have software that, for example, takes as input the results from a sensor device, what is it sensed in terms of depth information or density information of the earth, and then as a result, you're going to determine where to drill for an oil well, well, that could be considered a practical application of software. So we look at Canada's Patent Act. That's the first thing that patent examiners in Canada look at. The US Patent Act is somewhat similar in terms of how they define invention. It can be any new and useful art, process, machine, manufacture, or composition of matter, or improvement to one of those categories. And Canada has a specific exception. You cannot get a patent on a mere scientific principle or abstract theorem. So with regards to patentable subject matter, there are entire webinars devoted to this one particular slide. So I could go for an hour on just this topic alone. But there was a case called Schwafati versus Canada, and that was decided in August of 2020. And we kind of break it down in terms of what happened before that case, what happened in that case, and what happened after that case. I'll just really briefly go into it. Before that case, CIPO, the Canadian Intellectual Property Office, used what's called a problem solution approach to determining whether a computer implemented invention really needed the computer to be a part of the invention. If it was just something like pure investment advice and all they did was automate it, then the examiners at that time before the Shrafati case would say, no, the computer was not essential. So then you wouldn't be able to overcome that first hurdle of patentable subject matter. The Shrafati case itself had the Federal Court of Canada reject this problem solution approach and say that you have to do what's called a purposive construction of the claims. And that itself is something that has its own case law and can be discussed at length. But suffice it to say that if you found a technical problem, which is something that's similar to what Europe does, and you had a technical solution that you described in your invention, and that's what you claimed in your patent, then you could be able to claim the computer, or rather the computer could be considered part of the essential elements. So you would be able to overcome this. But the Shrafati court said that this is not the right approach to take. So CIPO, the Canadian Intellectual Property Office, issued a practice notice a few months after that, and they have a slightly different test than the problem solution approach, which might result in a lot of the same outcomes that the problem solution approach did, using the actual invention analysis, which basically looked at whether the patent application described something that you claimed had elements that required the computer or interacted with the computer or had some kind of necessity of the computerization of it to require there to be a computer, which kind of took the human being out of the equation, so to speak. So there have been some cases that we've been following, and when I say cases, I mean decisions at the Patent Appeal Board of Canada that have basically shown that if you can either demonstrate, one, that you've improved the functioning of a computer, or two, tied your invention to the real world. So they like to use the oil well drilling case. So the oil well would itself be a tie to the real world. Or for example, if you use computer vision, so you have a camera that takes as input something that's actually happening in the real world, those could be the ties to the real world that satisfy that second prong that Canada has. In the US, they have this case called Alice, which was a case that looked at financial hedging invention that was essentially automated. So it took the human out of the equation, but it essentially computerized what the human financial advisor would have done to advise somebody when and how to hedge their investments. And the Supreme Court in the US decided that this was too abstract of an idea, and that the way they claimed it was not statutory subject matter, or as they say in the US, patent eligible. So out of the Alice case, the USPTO, the United States Patent and Trademark Office, created what's called this two-step Alice-Mayo test. Mayo is another case, so they kind of combined the findings of the Alice case and the Mayo case, and that's in this flow chart on the right. And I won't go through it because it's there's a lot of nuance to it, but the bottom line is there a practical application of your abstract idea, of your algorithm, which in a lot of cases is very similar to the Canadian approach of, does it improve the functioning of the computer, or is there a tie to the real world? In Europe, they have their own test, which kind of breaks it down into two steps. Is there a technical character, and is there a technical effect? The technical character is the very easy, typically easy 99.9% of the time. You're successful in overcoming this just by saying that you are claiming that your invention is done on a piece of hardware, on a computer or on a smartphone. The meat of your arguments will come into the technical effect, and they look at this technical problem and technical means criteria. What they want to know is, does your patent application describe a technical problem? Does it describe a solution for this technical problem that uses a technical means? And are you claiming it that way? And usually when they say technical, they mean non-professional, non-business. So usually it means, is it something that results in improving network management, or does it help reduce the use of computer resources? Does it speed up a computer? Does it reduce memory requirements for a program? So I'm just using these as examples because this is most closely related to software as a service. Technical effect could even be something like how an escalator works. So, but I'm just focusing on the software aspect. So we're going to move on to trade secrets, another form of protection that Stephen will discuss.
Okay, thanks. So what is a trade secret? Well, I mean, we don't know, because if we knew what it was, it wouldn't be a secret. But basically, a trade secret is anything that, you know, helps your business, helps the value of your business, but that you can maintain the secrecy of it. And, you know, this could involve things like your contact list, your data, all those aspects that you've collected over time that you want to really keep secret, customer profiles, lists, anything like that. When it comes to technology, really, it's focused more on areas where basically things cannot be reverse engineered. We talked about that a little bit. As soon as you can reverse engineer something, then trade secret is probably not the best route to take. Things that are difficult to reverse engineer, we generally find to be in the space of formulations and things like that. So you can see, for example, the Coca-Cola is a great example of a trade secret. After all these decades, in fact, I think a century, no one really knows, you know, what the formula is for Coca-Cola. We know what the ingredients are. We have to list them by the labeling laws. They have to list the ingredients, but knowing the ingredients and making something when it comes in this kind of space are quite different. And so no one's been able to make the formula of Coca-Cola. Now, how do they keep it a trade secret? Well, they really keep it a trade secret through steps we're going to talk about in the next slide, really, in terms of protections and things like this. But here's, you can see a number of examples of trade secrets in the bottom here. Kentucky Fried Chicken with the batter for the chicken, of course, is a great trade secret. Google with the algorithms for the search engines that they've kept secret over many, many years. And Google is actually very interesting. I don't know if those of you remember when it first started off. They've really started off with it was called a meta search engine, basically. So Google did not have its own search engine. What Google did was they just compiled the search results from a number of different search engines that were available at that time. And then over time, they developed their own proprietary search engine. So it was a very interesting beginning. But I do remember Google, getting my way by age here, but I do remember Google in the early years. It was a very interesting way of searching multiple search engines at the same time. Okay, next slide. So if you do have something that could be a trade secret, and looking at the Coca-Cola formula, for example, how do you keep a secret? How do you maintain it? And really, you want to put into your company that culture. Okay, so for example, Coca-Cola, no single employee knows the full formula for Coca-Cola. That's how they keep that secret. People know what it is that they do in that process, but that's all they know. They don't know how it fits within other aspects. And so that's how they maintain the secret. If you have a product and it's a very top secret product and you want to maintain trade secret, people work on their particular portion of the project, but they don't know what it's going to be used in. They know what it can do, for example, what their particular piece can do, but they don't know how it's going to fit in the overall goals of the project. So you really want to put in place, these kind of processes through contracts, so people agree that they will keep what they are doing confidential. Potentially physical barriers, and those physical barriers could be encryption and passwords, so one group cannot interact with another group. Or it could be actual physical barriers in the sense that one group is in a different building than another group. So this is the kind of things you want to do for a trade secret. You have to treat it very seriously because, as we said, once the secret is out, it's out. You might be able to sue somebody for a breach of a contract, but you'll never recover. You'll never recover from that individual what you've lost once the secret's out there and other people can copy it. So trade secrets really is putting into place that kind of culture about how you keep things a secret. Now, do trade secrets and patents overlap? The answer is yes, they can. As an early stage company, you want to put in place, I would say, a trade secret mentality with your products and services. You want to keep everything confidential for reasons that we'll talk about a little bit later. You want to keep everything confidential, so you want to make sure everybody has understanding that this is a secret within your company. And then at some point, you will flip over probably to patenting that particular product or process. But you really want to think about the early stages where you're still developing things in the lines of making sure everybody understands that everything is treated as a trade secret. So next slide. So true or false? Keeping everything as a trade secret is the best protection. Absolutely. Can anything really be a secret? Sometimes yes, sometimes no. Proceed with caution. And the answer is, people are going to say another typical lawyerly answer. Sometimes yes, sometimes no. And someone says, can anything really be a trade secret? Well, yes, Coca-Cola is a trade secret. So, always proceed with caution. Early stage development, difficult to reverse engineer. You want to try and think of these things as trade secrets, vulnerable to public disclosure and independent discovery, definitely not. And there's a bit of an overlap, as I mentioned, between trade secrets and patents. And early stages, trade secrets probably the best way to think about it, even though ultimately you'll probably be proceeding with a patent application.
And just to add to that, one thing that I ran into with somebody who didn't use our firm, but I spoke to him about his invention, was how do I get protection in other countries? And I said, what's your situation? And he said, well, I just got a patent in the US. And I had to tell him the bad news. Well, you have to pursue patent protection essentially right away. Once you know that you're eventually going to be publicly disclosing your invention, you have to start thinking about what you need to do to protect your patent rights. Once you've disclosed your invention in any way, for example, a journal article or a public, let's say a presentation to Shark Tank, for example, it's in the public domain. This can be used as prior art against you. Now, Canada and the US have this 1 year grace period, but other jurisdictions like Europe don't. So so it's always good to think about patent protection as soon as you think of having an invention that you want to protect, especially if you're going to be disclosing it. Let's say even in a potential investor meeting, contact us and ask us for our advice so you know what to do next. So the next one that we're going to talk about, next topic, is copyright. So just in the interest of time, I'm going to get through this fairly quickly and just leave it for you to ask any questions if I've gone over something too quickly. But I'll let Stephen do the introductory discussion of copyrights first.
No problem. Thanks, Ray. So copyright, is pretty much getting into the artistic realm of intellectual property. So we often think of copyright in the context of books, artistic works, poems, novels, movies, music, and that's usually where we would think about it. In the company, for example, you would have copyright in things like logos, artwork, for example, on your packaging. So anything along those lines that could give rise to copyright, and you want to make sure that it's properly protected. The main thing with copyright, protecting copyright is that simple, but the main thing with copyright where most people run into issues is making sure they have clear agreements in place with whoever came up with the work and who is the owner of the work. So you have the author, the person who came up with it, and the owner. And the owner is the one who you want to make sure there's an agreement in place saying, you know, I paid you, even though you came up with it, I own it, and so the copyright is mine. And that's particularly important in a business because the last thing you want to do is have someone design the logo for you. And so that person has the copyright in the logo, and then you go to launch your product with that logo, and you may even get a trademark application for that logo, and all of a sudden find you don't own the underlying copyright in that logo. So there can be a blend there. So you want to make sure ownership and authorship are clearly delineated, and whoever you're working with, make sure you have agreements in place that they understand that even though they're doing it for you and being paid for it, that they understand that you will own the copyright. So copyright exists automatically, even in this presentation that Ray and I are providing. As we are providing it, copyright accrues to it. So copyright is one of those things that exists as soon as a work is created. So you can just think of it that way. It's very easy to have copyright arise, but you do want to make sure that you protect it through those mechanisms about agreements and ownership. So next slide. Copyright, you may think, okay, well, it seems pretty specific. It goes to perhaps the particular words on a page of a book, for example, and that's true. But copyright is very long lasting. And this is where you can get into difficulty. So it's a life of the author plus 50 years, or life of the author plus 70 years in the US. And that is a long time. And so if you do not have everything tied up neatly with a bow, and you have some underlying copyright issues outstanding because of authorship ownership disputes, they can be around for a long, long time. You don't want those dogging your company all those years. So definitely get them wrapped up. I'll give an example of one that happened. This is Nike. And of course, I mentioned the interplay between, the swoosh, which starts off as a copyright work, and the trademark. And the copyright exists in different countries. The trademark may not be registered in all those countries, and Nike had an issue where they actually had to pay somebody for that right to register their mark in a country for the swoosh mark over time. And of course, someone got very rich for that. So you really do want to make sure you own what you think you own and not have surprises down the road, sometime many, many years later. Okay, so the next quiz, Ray?
All right, so data is copyright protected, true, false, or maybe. And in keeping with the spirit of our answers, we'll give you a maybe. So there was a case where the court was looking at two kinds of data, raw data and processed data. And the question was, which of these is protected? So raw data is not simply pumped into a computer and a useful product comes out. So essentially, you have to look at each situation on a case-by-case basis. And there has to be some kind of skill, judgment, or creativity in what you're doing with this data for it to be copyright protected. But generally speaking, you can, if it's not just numbers, for example, that are automatically generated by a computer program. Next quiz, databases, are they copyright protected? And as you can expect, it'll be a maybe. So when you have databases, there has to be consideration of whether there was any skill or judgment in the selection or arrangement of the database. In this one case between TREB and the Commissioner of Competition, the data was almost instantaneously appeared in the database. So the originality threshold was not met, and as a result, the database was not copyright protected. Had the facts been a little bit differently, if there was some kind of creativity or judgment on the part of the database manager as to how the data was compiled and organized, the case might have come out differently. Next quiz, computer programs and code, are they copyright protected? So remember, this is, well, we're still within copyright protection. And the answer is, again, maybe. So in this particular case, I'm not going to get into all of the facts of this case, but the judge looked at the facts and said that there was insufficient evidence that the plaintiff's contributions represented exercise of skill and judgment. Now, I will contrast this with the next case. So in this one, the authorship requirement was not met. So we have to look at, well, where was it met? There was a case between Google and Oracle. Remember, this is the, these are big companies with lots of money riding on it. And here there was 11,500 lines of code. The court didn't actually rule on the issue of copyrightability, on copyright protection. Arguably, people said that yes, it would be copyrightable because other than if it weren't the case, there would be no real reason to go into a fair use discussion. But fair use, some of you might know this from watching YouTube, how you'll have these fair use claims at the beginning of a YouTube video where they say, we're borrowing other people's video, but it's considered fair use because we're not just reproducing it in its entirety, we're doing something with it. And that's what the courts look at is how much of it are you, or what's the nature of the copyrighted work that you're using? Are you transforming it in any way, or are you just showing it as is? And what the market effects are. So this is something that can go into. You can go into a lot of details about this. The court spends several pages on the discussion of fair use, but in this case, they did found that the use of the code was fair use. But don't think to yourself that you can just copy people's code because the facts might be different in your situation. So we're going to move on to software licenses. This is something that for people that are involved in software as a service, you'll want to consider, and that is software licenses give the licensee the rights to do one or more, if not all, of these four things that we've listed on the slide: to operate the software, distribute it, access to the source code, or modify or create derived works. There's different kinds of software. There's proprietary and open source. When it comes to open source software, you can find different kinds of licenses. So when you go on their website, on a particular website, and it tells you that it's open source, you want to find out what kind of open source software licenses you have. Is it public domain, permissive, or restrictive? Public domain means you can do anything. You can use it, you can modify it without restrictions. Permissive is where you're permitted to use it, but the requirements on modification and redistribution is minimal, such as just include a copyright notice. There are what are called lesser general public license, and I'll just let you read that. It's something you might find from time to time. And then finally, the restrictive or reciprocal open source software licenses. I've seen this to be more and more the case, because one of the things that you'll find is that they want to make sure that people are not taking the open source software and then deriving a business advantage from it and putting other people who are part of this open source community at a disadvantage. So they have such requirements as any modification can only be distributed under the same license. There has to be downstream licensing, and you cannot assert your patent rights against the licensors. So that's one thing that you have to consider when you're actually developing software that you're going to patent, and that is, am I using open source software that has these restrictive or reciprocal requirements, and will that affect my patent rights? And that's one of those things that our firm looks into and can assist you with. So finally, we're going to go into the section on good habits for protecting your IP. So I'll hand it over to Stephen.
Thanks, Ray. So here's a good overview of the different kinds of IP that we've talked about and some idea of the costs. As you can see, patents are definitely the most expensive. Designs and trademarks are probably next. And then copyright is fairly straightforward. As I mentioned, this is for the protection. Don't forget there's other issues here. So copyright may be fairly straightforward for the registration, but you may have issues in terms of agreements and things like that in place that you do have to get sorted out. And trade secrets, it says free, but I think that's a bit of a red herring. I mean, you do have to set up the infrastructure to maintain the secrets, and that can involve agreements, potentially physical barriers, encryptions, and things like that. So there's, once it's up and running, it's great. There could be no ongoing costs, but don't assume free is free, as they always say. So, what you want to do when you move forward with IP, you want to do some due diligence, and you want to take a look at what you can be considering. So, for example, on the next slide, you'll see you can go to certain things like public databases that are available. You can do trademark searching on the Canadian Intellectual Property website. There's a trademark database available there. Same with the USPTO, the United States Patent and Trademark Office. So you can do some searching there to see, what this is the mark that you would like to use. Has anybody registered it? We have our own proprietary databases that we search. We look for phonetic equivalents, as well as French language equivalents and things like this when we do a trademark search for you. But definitely it's something to consider. Obviously in the early stages, if you're at a point where you would rebrand, should something pop up, it's not a big deal. But if you're going to be launching a product or a service and maybe spending, like a $700,000 in marketing campaign, the last thing you want to do is launch something and all of a sudden find out that someone else has got a similar name or has an issue with you using that brand or name. So definitely think about searching and, think about where it is you're going to be with this product or service. Will rebranding be of concern if you are infringing someone's rights and things like that. So just, these are kind of tools you can use to help mitigate some of those things. Patents databases are also available free. Google Patents is a great site you can access. Same with USPTO or Canadian equivalent. And again, our firm will do searching on proprietary databases that we have access to. That basically will allow us to extend those searches globally, and in some cases to different foreign language jurisdictions, like for example, China, Korea, Japan, where we can access Google translated documents as well to see what's available out there. Because don't forget the newness and obvious tests that we talked about. Those disclosures can occur anywhere in the world, and it doesn't have to be just Canada or the US. So you do want to make sure you're quite well aware of what's going on out there. And the more information you have, the better armed you are when it comes down to arguing with the patent office. We call this front loading the application, by the way. In other words, I remember one litigator, and they basically said, you never ask a question in court of a witness that you don't already know the answer to. And the same thing could be said for patents. You don't want to file a patent application, or you want to try and minimize the filing of a patent application where the objections by the examiner, you probably, you kind of have an anticipation of what they're going to be. So if you think of it from those points of view, it's called front-loading the application, and it can really minimize downstream costs when you're in that bargaining process. Ownership and confidentiality, again, some good housekeeping rules when you're setting up a company or setting up your business. You want to make sure you have at the outset all the agreements and things in place that whoever is part of the company, employees, contractors, partners, etc., that the ownership is clear and have that in writing. This is one of the worst things for a startup company is they often don't have these things in writing, and a lot of disputes in the early stage companies, people think it's big companies suing them for infringement or things like this. It's not. Actually, a lot of disputes in early stage companies are in ownership. Maybe partners have a disagreement, they go their separate ways and try to implement the same invention. So you want to make sure it's clearly in place that whoever has come up with it, the company owns it. And you want to make sure that's clearly written out there. As I said before, you want to make sure everything that you've come up with, you want to keep that aspect about secret there. So treat it as a trade secret. And the reason is Ray mentioned, once something is out there, you could be prohibited from filing a patent application in many jurisdictions around the world. There is a grace period for Canada and the US and a few other countries, but by and large, most countries of the world, it's what we call absolute novelty. Once it's out there, you're prevented from filing. So you want to have a mentality of keeping everything secret until you've made an informed decision that you're going to proceed with a patent application or not, and you're willing to live with your decision. You can use non-disclosure agreements where necessary. So if you do have to disclose it, you want to try and do it under an NDA. So if you're meeting somebody saying, I need to move my business forward, try and do that under an NDA. And if they don't sign an NDA, you are going to then be faced with the decision, do I file a patent application then before I disclose it to them, which is your best defense? Or how can I trust that person, and will that be a disclosure, and what will the implication of that be? So these are the kind of things you want to think about in the early stages of your company. So how do you capture innovation? It's not too difficult in an early stage company. It could be the main thing that you're working on. But as you develop things, it was mentioned, I think Ray mentioned it, there's a number of improvements that pop up. And it's not uncommon for a company to have their first filing, their first innovation, and that's what we call the foundational technology. And off of that, you will have a number of improvements, and they form, subsidiary patent applications for each of those improvements. And in a sense, by filing this foundational patent and then a number of improvement patents off of that, you're building a wall around your technology. And when you look at licensing, if you look at companies that license technologies, they're not licensing a patent. They're licensing technology covered by a number of patents. And with those patents, you could have a foundational technology as well as a number of improvements. And it's always better because, the saying is never have all your eggs in one basket. Same thing with licensing technology. You don't want to have all your eggs in one basket, i.e. you're only licensing one patent. By licensing technology covered by a number of patents, it makes it very difficult for the people you're licensing to invalidate a particular patent. So they'd have to go after all the technology. It's too expensive, and then they're more likely to license it. So how do you keep track of these innovations and improvements? Depending on the size of your company, you want to basically intake the improvements. This could be something called an innovation tech disclosure form. So the people come up with improvements, they fill this out. A committee would often review this to see which ones are worthwhile pursuing, which ones aren't. They may do some investigations into it and determine, okay, we'll proceed for this patent application for this one, or we'll keep this one secret, or we'll let this one perhaps fall into the public domain. So that's usually how it kind of plays out. So when you're looking at patents, what are you looking at? You want to look at what are the strengths and weaknesses of your business. You want to align your strategy and your IP strategy with the business goals. Having an IP as a checkbox, in my view, is not a good strategy. You want to know, where am I today with my company? Where am I going to be a year from now, 3 years from now, 5 years from now? And how is the IP going to help you get there? Whether it's patents, trademarks, trade secrets, whatever. How does that line up with your business goals for that time frame? And you want to speak with your IP advisor and really kind of just line that out there and say, this is where we want to be, and how are we going to get there? And what IP do I need to help us get there? And it can change if your company pivots. What was important today may not be important 3 years from now, and that's okay. It's a living, it's a living thing. As your business strategy evolves, your IP strategy needs to evolve as well. And so there's always an ongoing discussion with that. Okay, next slide. IP is just one part of successful business. Really, you want to keep everything lined up. When you think about it, what are your goals? Are you looking at protecting, attracting investors? commercializing, licensing, protecting goodwill, for example. All these things you want to kind of put on the table, plan it out over the next reasonable time frame for your business, and just figure out, okay, how's the IP going to help us achieve these goals? And so that's where we are today. So any questions? I think there's some in the chat, actually.
There's one question that I wanted to address early on that Stephen really quickly answered was, can anything really be a secret? And the answer is, for trade secrets, yes. I can't think of any case where it's gone to court where the court outright said, no, that doesn't qualify to be a trade secret. So I think the answer is yes. I can't give you a definitive no, because I haven't looked at all of the case law, but I think just about anything can be a trade secret. And it's an important consideration for inventors who are doing their innovation in software or computer implemented inventions, because sometimes there may be an issue with subject matter eligibility or statutory subject matter. What you have as an invention that you are considering patenting might encounter resistance at the patent offices, whether it's Canada, the US, or Europe, and you might want to consider trade secret protection for it, such as Google's algorithm on how they get their search results. So some things might be better suited for trade secret protection.
Yeah, and going back to for trade secrets, I mean, really it's keeping everything confidential and secret, but also just thinking about the perspective of, once your product or service is out there, can someone reverse engineer it? And if the answer is yes, then probably, well, you've kind of answered your question. The secret's no longer possible. This is why it works well for formulas and things like this, because even knowing the ingredients, it's very difficult to actually reproduce the exact formula that could be very valuable to a company. It's less so in the case of patents and services. Although having said that, some companies, their model is people give them their data or whatever it is they have. The company does whatever they do in a black box within the company, and then they return back a product. In that case, you could perhaps keep what's going on a secret if you can have that kind of model. And to Ray's point, I agree. I've never seen a case law discuss whether something could be a trade secret or not. Most trade secret case law really revolves around the breach of contracts as an employee leaves, for example, a company.
So there were some questions in the Q&A section of the Zoom interface. I'll just go through them one at a time, and I'll either answering it or Stephen might. First one was, do I have to register my company name before I incorporate? So that's outside of the topic that we're discussing of IP protection. But generally speaking, I think incorporation serves the same purpose as company name registration, but you'd be best off speaking to a corporate lawyer if you want to get a specific answer on that.
Just before we move on, just don't use registering a company name with registering a trademark. They're very, very different. The company name is what you do with the corporation's branch. A trademark is what you do with the trademark office, and they have very different scopes and ambits of protection. So you ultimately will want to register a trademark as well as incorporate at some point.
Right. Great catch there, Stephen. I always have to remember that sometimes people ask questions that overlap different areas of law. So that's a great point. Question, a long one from Mariello. About 3 years, I created a guiding principle to invent a technology that'll be able to pair and connect many headphones simultaneously using one port. Unfortunately, that was stolen by a Chinese company while I was in discussion with them for product manufacturing. Currently, I'm working on a software product that has not existed in Canada and the USA. I'm wondering how I could protect. Stephen, do you want to maybe take that one?
Yeah, so I mean, basically, if what you're working on is something that meets the criteria of being new and unobvious, and is patent eligible subject matter, then I would probably have us take a look at that, or have a patent agent take a look at that to see if it's something that could be patentable or not. Again, everything has to meet the requirements of being new and unobvious and patent eligible. And probably, to be truthful, a search is probably something that would have to be done to get kind of the ambit of the project, but definitely is something that to be looked at.
Okay. I think that was also part of the second question: protect the idea and the components associated to the product model. So yeah, we'd have to know what the idea is and what your inventive concept is. Then we could recommend, we might recommend a patentability search, and then determine whether you have one invention or multiple inventions, and determine if we want to draft a patent application or more than one patent application. Question from Edwin Gomez: what happens when the government takes over your work in equations, new work in technology? I'm not exactly sure what direction this question was heading in. I don't know, Stephen, what do you think?
I mean, so in terms of the patent space, there are provisions in the Act that if your invention relates to military technology, for example, the governments can basically what they do is they will prevent it from being published. So they basically put your application under an envelope. In the old days, sealed envelope, until the national security is no longer of concern. I'm not sure if you're going with that particularly, but if that happens, of course, you're probably being contacted by the Department of Defense at some point. The governments generally don't take your work or equations. I'm assuming if you're negotiating with them, I mean, they would normally do that. Or if they do, they would do it under a compulsory license regime, for example, where they would dictate what they will provide you for a license for royalty. Anyway, yes, I'm not exactly certain where that question is going from or coming from, but they don't normally do that in terms of in Canada anyways. And I will say in terms of the military one in Canada, I haven't seen that in my entire career. So it's pretty rare that would happen, perhaps more in the US or China or other countries, perhaps.
Okay. And finally, there was a question in the chat window, and that was: how do you identify which parts of the innovation within the SAAS need to be protected via IP? So that's a combination of a business decision and a technological decision. So the first thing that I would look at is this something that is part of your business in terms of is it something that you will be deriving a competitive advantage from in the marketplace? And if it is, then generally speaking, you do want to protect that innovation or the inventive concepts of that innovation, either by trade secret or by patents, and keeping in mind that there are different considerations for both, like we were talking about earlier. If a trade secret or something that you've decided that you want to protect by trade secret is something that somebody could either reverse engineer or just look at it and say, you know what, now I know what the input is and what the output is, I can figure it out on my own to get the same effect, then at that point, your trade secret's value has decreased or even been completely negated. So these are the kinds of things that you need to be thinking about very early on, especially before you make any kind of public disclosure, which public doesn't necessarily mean to the public at large. It could just be a sales pitch to a group of people who have not signed a non-disclosure agreement. Is there anything that I missed on that, Stephen?
No, but just want to one thing, people often forget family and friends in there as well, and they think that's confidential. But I will say that unless you have an understanding with your family and friends that what you've talked about is confidential, don't assume it's confidential. Sometimes they're the worst leaks. And so if you have disclosed anything to family and friends and have that understanding, you may want to go back and just make sure that they understand that what you talked about is to be kept confidential. And again, I hate you may not want to have your family or friends sign an agreement, but it's probably best to get them to sign an NDA as well. It's something people don't often think about, but yeah.
Right. So generally speaking, when we talk about software as a service, I think that the general notion of what's going on is that, let's say, for example, you have a website and you allow your customers to access a software service through your website. The classic case would be Microsoft Office through the Microsoft website. So you don't actually have Microsoft Office installed on your computer. You just go on their website and you use a version of Office that's accessible through, for example, your Google Chrome browser. So in that sense, software as a service is treated much like any other kind of software, and it falls under the general category of a computer implemented invention. That's how they're categorized by most patent agents or most patent examiners. So just getting back to like, how do you identify the parts of it? You look at what is the inventive concept, what technical solution, what technical problem you're trying to solve, and how you're implementing it, and then assess, usually with the help of a patent agent, whether it's patentable subject matter, and then, for example, do a search of patent publications to see if it is in fact novel and not obvious in light of what's called the prior art. So any kind of previous patent applications or patents or journal articles, for example.
Right. And on that, just to further elaborate, when you have something that's patented, I think the human mind naturally goes to, there's an aspect that is unique, and so a patentable aspect. And that can be true, and quite often it could be a mechanical component or a particular step in a process. Software is often viewed as a process. But it can also be a combination of things. So it could be a combination of parts or a combination of steps in the process that are the unique aspect, or the order that they're applied gives rise to a new result that wasn't realized before. So the question is a little interesting, and it's not something that can be done, in isolation, and the answer can vary depending on the inventions and the processes, and really requires a search to kind of get the boundaries of what the project is, and a bit of knowledge about what the problem that was solved and how you came up with a solution, to kind of understand what is the relationship between the various parts or processes, and how do they interact, and then you can kind of answer, what aspects of that could be protected by a patent, for example.
So I hope we answered all of your questions thoroughly and answered the intent behind your questions as well. The Q&A is still open, the chat's still open, so if we have any other questions, please feel free to add those. So I guess we can give it one more minute just to see if anybody wants to add any more questions, either in the Q&A or the chat window.
We've also given everyone permission to speak, so if anyone wants to just ask the question live, please go ahead. Mariello, do you have a question? No. Okay, well, I think you gentlemen solved everyone's problems already, so we're good to go. I will send out the recording as well as the contact information for Stephen and Ray in case you want to start on your patent journey. So with that, I will say goodbye to everyone, and hopefully we will see you at another session shortly.
Right.
Perfect. Okay, thanks everyone.
Thank you.
Thanks, Stephen. Thanks, Ray. Bye.
Bye.
Bye.